Okay, today's lecture is going to be the first portion of agency law. So we're going to cover about half chapter 16 with this lecture today. Let's go ahead and get the screen up and running. All right. What we see, agency law is really the foundation for a lot of tort-based law that we've already covered this semester. When you see a lawsuit filed against Walmart for one of their trucks, their 18-wheelers hitting someone else, why don't you see the truck driver individually being the sole defendant named? And the reason is very simple, that the truck driver is working for Walmart and they are their employee, their agent, and under principal agency theories of law, you can hold the principal liable for the actions of the agent that are committed within the course and scope of their employment. So it's very important for you to understand this principal agency relationship and how it connects with the law to assign responsibility in given situations. It's not just tort law, it can be contract law as well, and some other things that we're going to talk about during this section. If you see the second bullet point on this particular PowerPoint slide, you should hone in on this as one of the integral elements of principal agency law. The principal has the right to control the agent in matters entrusted to the agent. That element of control is key. And it doesn't matter. A lot of people don't understand this, but it doesn't matter whether they actually control the agent or not. What is important is they have the right to control the agent. In fact, there have been many times when the principal has taken a hands-off type of attitude with respect to the principal, but when they do so, with respect to their employee or their agent, when they do so, they are foregoing their right to control the agent or the employee, and they're still held responsible for the actions of that employee slash agent as long as they were committed within the course and scope of their employment relationship. Now, one of the things that'll be important for you in real world law, as well as for purposes of the exam, and I know the exam is always important for you as well, is to make a distinction between an employee who would fall under the principal agency theory as contrasted with an independent contractor who would not. Generally, there are many different factors that the courts use in making a determination of whether a particular worker is an employee or an independent contractor. The first, and we're going to go through each one of these categories a little bit. The first one is, does the employer, or let's call it the company, because you're not going to have an employer of an independent contractor. If they're an independent contractor, it's a company hiring an independent contractor. If they're the employer, then it's obviously an employee. So the first one is, does the company exercise a great deal of control over the details of this work? And you probably know or can guess by now that when they do, they're probably an employee as opposed to an independent contractor, or at least that's a factor that falls on the side of them being an employee-employer relationship. Second one, is the worker engaged in an occupation or business distinct from the employer? You hire Acme Landscape Company to put in bushes and shrubbery for your business, Jeff State Community College. Acme Landscape Company is in a different occupation or business than Jeff State Community College, and as such, Acme is probably an independent contractor and not an employee. Now, what if Jeff State is merely directing their maintenance personnel to dig up some bushes or shrubbery or whatever and place that on their property? Well, if that's the case, then that worker is not in a different business than Jeff State Community College, so they're probably going to be considered to be an employee as opposed to an independent contractor. The third one, and by the way, even though I'm numbering these and going through them in a numbered basis, it's important to realize that the factors are not determined by number. Well, I had 9 of them this way and 7 of them this way, so it's got to be the one that's 9. That's not the way it works. Instead, it's just looking at everything as a whole. Which one is the carries the great weight of authority, I guess, for lack of a better word, in determining whether someone is an employee or an independent contractor. And again, I will submit to you that very first one that we looked at, does the company exercise a great deal of control over the details of the work, over the worker itself, himself, herself? That control element is the most important one. Third element, is the work usually done under the company's supervision? If it is, then yeah, more than likely they're going to be an employee, or at least that's another factor that would indicate that they're an employee. Does the company provide the tools? Company provides the tools, it's a factor that indicate they're probably an employee. Has the worker been working for them? I'm not going to say employed because that's giving the answer away, but has the worker been working for them for a long time? They go in every day, the same company, work for nobody else, probably an employee. Is the worker paid at the conclusion of their job? Not on an hourly basis, not on a weekly basis, not a bi-weekly basis, not monthly, but the conclusion of the job. What does that sound like? Sounds like an independent contractor to me, and yes, it does. I almost want to skip the last one because I think it's totally irrelevant and highly misleading. Is there a great deal of skill required? This claims that if there is, you're likely an independent contractor as contrasted with an employee. I've got some doctor clients of mine who are employees of hospitals that would be very surprised to learn that they must not have a great deal of skill because they are employees. See how stupid that sounds? It's very stupid. I would ignore that last one. I just don't think that's very relevant. I understand where they're coming with it, but as a general rule of thumb to work with, it's not very useful. Now, let's talk about a couple of the things that are important on after we've classified this worker as an employee or an independent contractor. What difference does it make? Well, it makes a big difference, a huge difference. I'm going to look at the last hyphenated point first. Tort liability, which is what I started the lecture today talking about, and what we started the class talking about in general. The usual rule is that an employer is responsible for the tortious actions of its employee committed within the course and scope of their employment. Now, we'll talk in a minute about what is within the scope of the employment and what is not within the scope of the employment. But suffice it to say, for purposes of tort liability, generally the employer is going to be liable for the employee's actions. What about an independent contractor? Again, we're going to find an exception we'll talk about, but the general rule is a company is not responsible for the tortious actions of its independent contractor. We hired Acme Landscaping Company as an independent contractor earlier. What if their truck that is carrying the bushes and the shrubbery and the things that it is going to put in on our property, what if that truck runs over a student, or even worse, a teacher, while they're on our premises before they put them in? Are we going to be liable? Are we, Jeff State, going to be liable for the actions of Acme Landscaping Company? And the answer is no. We are not liable for their actions because they are an independent contractor and not an employee. We are not responsible for their actions because they're not our employee. They don't fall under the principal agency theory. And if you think about it, it makes sense. Think back about those factors we were looking at in the previous slide. We're looking at control. We're looking at supervision. We're not training the people how to drive those big trucks. We're not teaching them how to do it. We're not selecting the people that are the drivers. We're not selecting the trucks to assure their safety, etc. We're not controlling them, etc. So the independent contractor themselves is going to be liable, but not the company. On the other hand, if you have one of our maintenance people and they get in their Jeff State truck and they run over somebody, well, Jeff State's going to be liable for that one because we're running over our own. And I'm picking on Jeff State. Obviously, you can put any company in there and it works just the same. I'm just using an example that's near and dear to our hearts at this point. Contract liability, tax liability. I'm going to mention tax liability here quickly. In general, some of us may have been a 1099 worker before. We may have heard it called 1099 worker. And basically what that means is that we're receiving, instead of a W-2 at the end of the year, we're receiving a Form 1099. It also means that during the year when we're paid for our work, our boss, our company, the company that we're working for is not cutting taxes out of our paycheck. And we love it during the year. But what happens at the end of the year? At the end of the year, when tax time comes, guess who's responsible for paying their taxes? All of their taxes. We are, as the independent contractor, as the 1099 worker. As an employer is responsible for not only withholding payroll taxes out of your paycheck, but also matching certain taxes, FICA, Social Security taxes as well, if you are an employee. So it usually benefits a company to call you an independent contractor and pay you the full amount, because then they don't have to match what they're withholding in FICA and Social Security taxes out of your paycheck. It benefits them. You think it benefits you. It benefits them more because they get to deduct all of it from their taxes, and yet they don't have to match anything. They don't have to pay any taxes on the Social Security and FICA. I had a case, I'm not going to bore you to death with this, but I had a case many years ago involving a trucking company. And the trucking company had hired truck drivers to drive their trucks. They're over-the-road trucks, long haul, all over the country. And truck drivers, you may not know, but there are many that actually own their own trucks. They own their rigs, and they work for whoever they want to. They are true independent contractors, and they get paid accordingly. And then there are others that drive only for one company. The company owns the trucks. They pay for everything, the gas, the maintenance, everything. And the drivers just drive the truck. Those are the employees. Well, unfortunately for my client, my company had owned their trucks, owned the gas, and paid for the gas, the maintenance, oil, everything. And the drivers just worked for them. In fact, the first time, and I was a young attorney, the first time I was sent over to their office, working for a large firm, I was sent over to their office to talk to them about this audit that they were under and this assessment that they had been made, assessing them with about $600,000 of Social Security and FICA taxes. I walked in the door, I opened the door, I closed the door. Before I even introduced myself, I looked up on the wall, looked up, and I saw something. I saw a plaque, and the plaque said Employee of the Month. And it had one truck driver after another truck driver listed month after month after month. And I looked up and I told him, I said, take that down. Please take that down. Change it to truck driver of the month. Because we were calling them all independent contractors. We weren't cutting any taxes out of their paycheck. We weren't matching any Social Security taxes. So with all of that, we still called them an employee. Just can't figure sometimes. In any event, we resolved that matter, and it went away, and we just agreed to in the future treat them as employees, and so it was kind of a win for my client, but it was very scary there for a period of time. As you can see, very important to determine the difference between those persons. That second and third bullet point are really important, and I want to mention that no consideration is required. We have talked about contract law, or if you haven't had that yet, you will, and you will talk about consideration being required for a valid contract, something of value changing hands, something between the plaintiff and the offeror and the offeree. Well, this is one of those rare circumstances where it's kind of like a contract, principal agency relationship, but not really. It doesn't have to have all the elements. No consideration is required. You can have a principal agency theory just for the fun of it, just because you want to, just because you think it's the right thing to do, gratuitous, doesn't matter. The next one, the principal needs contractual authority, but the agent does not. In theory, won't happen much, but you could have a situation where you have a normal, regular principal, has capacity, perfectly fine, mentally competent, of age, etc., and they have a 14-year-old acting as their agent, maybe lacking capacity, full capacity to enter into a contract that's not voidable. You could even have someone intoxicated or mentally incompetent, and they could still enter into a contract on behalf of the principal as long as the principal has capacity. Now, the next section is discussing different types of agency, and for purposes of exams, generally I don't try to say what kind of agency was this, what kind of agency was that. Instead, what I generally try to do is to identify or illustrate a hypothetical situation. And in that hypothetical situation, you may have to determine whether an agency relationship exists or not. And of course, in order to do that, you've got to know how agency relationships are initiated in the first place. So you have to know how agencies by agreement exist and how they're formed, how agencies by ratification exist and how they're formed, how agencies by estoppel and agencies by operation of law. So you still have to know this. I'm just telling you the way that I test on it isn't, try to identify it this way or that way. You should know by now, this part in the semester, that it's much more important for my purpose and for your purposes on the exam for you to be able to apply this law in a practical way and to determine what your rights and exposure may be in a given situation. And that's why I ask the questions the way that I ask the questions. So let's go ahead and go forward with this. Agency by agreement is real easy. You just agree to it. Well, hey, will you be my employee? Yeah, I'll be your employee. Usually it's for compensation. It doesn't have to be. Usually it is expressly agreed upon. You know, hey, will you do this for me? Yeah, I'll do that for you. Doesn't have to be. It can even be implied by conduct. You just start working for me. You just start doing things for me. And it is, that's agency by agreement. Doesn't have to be in writing either. Agency by ratification. To ratify something means to approve it or to agree um, about what previously occurred after the fact. After it already occurred, you agree to it. And the principle in an agency by ratification, either by their action or by agreement, will ratify the conduct of a person who wasn't supposed to be the agent but was acting in that way. Example that I like to give is let's say that I'm a farmer and I use fertilizer in my business. And you just happen to know I'm a farmer, and you just happen to know I use fertilizer in my business, and you just happen to be at a place where there's a going out of business fertilizer sale, and you can get just a ton of fertilizer for 10 cents on the dollar. But you don't need fertilizer. You're not a farmer. I am. But you like me and you want to help me out if you can. So you go to them and you say, hey, Mr. Cartwright agrees to buy a ton of your fertilizer for 10 cents on the dollar, whatever that price may be. And you come back to me and I say, great, that's wonderful. I approve and I go ahead and go forward with it. I have ratified that agency relationship by approving it. Now, the interesting thing on an agency by ratification is that it's an all or nothing kind of deal. I thought it was the part of that next PowerPoint slide, but apparently it is not. Um, you can't ratify a part of the deal. You've got to either ratify all of it or none of it. So if you came back to me, you told me that you entered into an agreement to buy 2,000 pounds of fertilizer, and I said, I'll take 500. And I go to the company that was selling to you and said, they agreed to do it on my behalf, but they didn't have the authority to do that. I'll buy 500 instead. The company is perfectly within their rights to say, no, sorry, you've admitted they're not your agent and you didn't ratify that agency because you only ratified part of it. It's either all or nothing. Agency by estoppel is always an interesting one. That estoppel means you're stopped from denying something that would be detrimental to yourself by your own conduct. One example that doesn't fit perfectly here, but it's pretty close, is a colleague of mine once worked for a law firm. He wasn't a partner in that law firm, but they acted like he was when they introduced him to their clients, to their other colleagues, to suppliers, vendors, that kind of thing. Hey, this is John. He's the new partner, blah, blah, blah. Well, it turns out John decided he was going to use one of the firm's vendors to help furnish his own new office. When I say new office, I mean competing with them, starting in his own firm. And so he went to the furniture supplier and he said, look, you need to please sell me this furniture and deliver it down the street at this other building. Put it on the firm's tab. And they did. And the firm came back later when they got the bill. This lawyer had left by that point. They got the bill and they said, whoa, whoa, whoa. We didn't buy that. We didn't authorize that. He didn't have the power to do that. He didn't have the authority to do that. The supplier said, look, you're the one that told us he did. You said, hey, come meet our new partner. Look, he's our new agent, employee, fiduciary. And they were right. Now, did the firm, that first law firm, have the right to go after the lawyer and make that lawyer pay them back for that? Sure they did. Obviously they did. But the point is that the company, the furniture company, the vendor itself had the right to go after the law firm because they were stopped from denying that agency relationship. Agency by operation of law. The easiest one to give example to give here is, let's say there's a medical emergency and person falls out in class while they're listening to me when we have an on-campus class, and they get bored to death, they fall asleep, they roll out of their desk, hit their head on the floor, and they're unconscious. I keep teaching because that's what I do. You're nicer than I am, or you have a classmate that's nicer, and the classmate calls an ambulance. The ambulance takes you to the hospital and everything's fine until you get the ambulance bill. And you say, whoa, 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 wait a minute. I didn't authorize that ambulance. I didn't authorize my classmate to call the ambulance for me. They're not my agent. They're not my employee. They're not my representative. All the ambulance has to do is say, look, you got an agency. You may not have known it, but you got an agency. You must have fallen asleep that day, Mr. Cartwright's class, because you've got an agency by operation of law. It's based upon a duty that was created by that social emergency that existed. And there's a little chart that's pretty good with that. None of this, the next slide is very difficult. So I'm just kind of going to skim over and just address it. Basically, the agent owes duties, fiduciary duties, duties of loyalty to the principal, duties to notify them, duties to act reasonably in a reasonable way, to exercise whatever diligence and skills that they're supposed to have in that position. What does the principal have to do? The first one, generally, as a general rule, even though I said you can do it for free, the first one is generally they got a duty to pay you compensation, to reimburse you for expenses that you as their agent incur on their behalf, to indemnify you against harm and damage that exists, etc. I don't generally ask the difference between actual authority and apparent authority, but you can see apparent authority would exist for estoppel, agency by estoppel, and agency by ratification, as well as agencies by operation of law in an emergency situations. Okay, that's it for part one of agency. I have a second part of agency that is an audio lecture, and so make sure that you watch that portion as well. Thanks, guys.